Wondering why a person can't be tried twice for the same crime? Or how an appeal process works in the court of law? Or perhaps what special provisions are there for individuals deemed to be of unsound mind? Today we'll delve into these legal intricacies, starting off with the concept of previous acquittals or convictions. This is covered under Chapter 30. This principle, encapsulated in Section 403, is known as double jeopardy. It's a fundamental concept in law that prohibits an individual from being tried again on the same or similar charges following a legitimate acquittal or conviction. So, if John Doe was acquitted for a burglary charge, the state can't prosecute him again for the same offense. Transitioning to Part 7 of Appeal, Reference, and Revision, we'll first tackle appeals. This portion, spanning from Section 404 to Section 431, outlines the appeal process. It's a procedure for requesting a formal change to an official decision. It's how a decision made by a lower court can be reviewed by a higher court. If Jane Doe believes that the trial court made a wrong decision in her case, she can appeal to a higher court to review and possibly reverse that decision. Next, we delve into reference and revision, covered from Section 432 to Section 442. This section provides the higher courts the authority to call for records of any case which has been decided by subordinate courts. It also empowers them to correct any irregularities or errors apparent from the face of the record, ensuring that justice is served. Lastly, we move on to Part 8, Special Proceedings. This part is particularly focused on provisions for lunatics, as covered from Section 464 to Section 475. It outlines the procedures and protections in place for individuals deemed to be of unsound mind. These protections ensure that individuals with mental health conditions are treated fairly within the legal system.
Have you ever wondered how the wheels of justice turn when it comes to dealing with offenses that directly affect its administration? Let's unravel this intricate web together. We begin with Chapter 35, which is specifically dedicated to proceedings in case of certain offenses affecting the administration of justice. Section 476 to Section 487 lay down the procedures for how these offenses are handled. In simple terms, these sections outline how a court must take action when crimes against the administration of justice occur. They also specify the steps a court must take to ensure justice is served. Moving on to Chapter 37, we delve into directions of the nature of a habeas corpus. The Latin term habeas corpus means you shall have the body. It's a writ requiring a person under arrest to be brought before a judge or into court. Section 491 and Section 491 detail the application and execution of such writs. These sections ensure that no person is unlawfully detained or imprisoned. As we continue our journey, we arrive at Part 9, the supplementary provisions, which includes Chapters 38 and 39. Chapter 38 specifically deals with the role of the public prosecutor. Sections 492 to 495 outline the appointment, duties, and responsibilities of a public prosecutor. A public prosecutor is a representative of the state in criminal proceedings, ensuring that justice is served. Chapter 39 focuses on the concept of bail. This chapter, through Sections 496 to 502, explains the conditions under which a person can be released on bail, the powers of the court in granting bail, and the consequences if conditions of the bail are violated.